Good evening to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss actually the case of law of torts, particularly the MVAct compensation. You know, the Motor Vehicles Criminal Claims Tribunal (MVCT). It is established and you file cases under section 166 of the MVAct to claim compensation because we can't get back the deceased who is involved in a road accident and his bereaved family. They will be suffering very much and they have to get some solution. For that purpose only, the law of torts deals with the Motor Vehicle Claims Tribunal. You know, in every court or in every district court, particularly the ADJ cadre people, they will be the president of the so-called MV Claims Tribunal. They will decide the cases. Normally, in 95% of the cases, you will get the so-called compensation, provided the deceased has driving license, all other things, the conditions will apply. Now, in this connection, so one of the students asked for the so-called Darla Verma case, which is defining the concept of just compensation. So I am giving you the details of Darla Verma. Darla Verma and others versus Delhi Transport Corporation (DTC), right? So in civil appeal number 3483 by 2008. So you can read the case as Darla Verma and others versus DTC 2009 because the judgment was delivered on 15 of April 2009. Right. We'll go to the facts of the case. The brief facts of the case are like this. On 18/4/1988, a road accident took place. There is a road ravage wherein the deceased Rajendra Prakash, who was working as a scientist in ICAR, that is Indian Council of Agriculture Research, he was involved in a road accident in which the bus belonging to DTC bearing number DLP 829 of so-called DTC, Delhi Transport, hit the motorcycle of the deceased, due to which after some time he died. Alright. At the time of accident, the deceased was aged about 38 years and he was drawing a salary of rupees 3,402 per month. Right. So the deceased wife, that is Darla Verma, and others, they filed the compensation petition under section 166 of the MVAct. So the widow, number one, 3 minor children, out of them 2 are girls and 1 is a boy, and parents of the deceased as well as the grandparent, only one of them, grandfather. So all of them filed claim for 16 lakhs before the MVCT Delhi. Now their claim is for 16 lakhs. But of course, the tribunal calculated and delivered its award. Actually, we can't say judgment, but anyway, for example, for practical experience, let us say it is a judgment. On 6/8/1993, the tribunal awarded 5,94,000 rupees. How the calculation is done? This is called multiplier theory. Basing on the multiplier theory, since the salary was 3,402 and 1/3 has to be deducted as a take-home salary or living expenses, then 2,402 was calculated and his retirement is expected at 60 years. That means 22 years amount was calculated and it has come to 5,94,000. That much amount was ordered with 9% interest till their payment is over. This is what is called multiplier theory. That's why the judge cannot issue himself this much. He has to depend on the so-called multiplier theory. So in this amount, 3 lakhs will go to the widow, 75,000 for each for the 2 daughters, and for son 19,000, and for the grandpa 30,000. Like that it has been distributed. But anyway, this is not liked or this is not accepted by the so-called Darla Verma, and ultimately she has gone to the appeal before the Delhi High Court. Of course, Delhi High Court considered the important point, that is promotion. In case he gets promotion, he will get 6,606 rupees. So it was calculated at the rate of 6606 and they have come to the figure 7,19,624. So the judgment by the Delhi High Court on 15/2/2007 enhanced the amount to 7,19,624. Right. Now, even against this woman approached the Honorable Supreme Court of India. You know, that is the final arbiter or the appellate authority. So Supreme Court said the compensation awarded is not just compensation. What is just compensation? Suppose if he is drawing a salary of 15,000 per month or so, the amount would have been 20 lakhs or 30 lakhs. That is not just compensation. That compensation. What is just compensation? Adequate compensation. Adequate compensation. Here the members are 8. So they should be adequately compensated. The children should study well. They have to pursue their marital prospects. All these things should be there. The woman, the widow, she has to lead the family life. So therefore, they calculated and enhanced the amount to 8,64,870. So here, in this case, the important point is the Supreme Court worded just compensation as adequate compensation, not the figures. Not the multiplier theory. Of course, you know, this court has got discretion, but normally the tribunal, they will act on the multiplier theory. Otherwise, one day or other Supreme Court may also comment on this court. But anyway, since it is the Supreme Court, they have stated that just compensation means adequate compensation, and therefore they have added some 1,25,000 or so. Ultimately, the figure came to 8,64,870. So this is the judgment delivered by the Honorable Supreme Court of India in the year 2009, and it is a landmark judgment. So whenever the adequate compensation or just compensation you want to claim, you have to cite this case law without fail. Okay, thank you.